only process known to international law whereby an independent people may yield their sovereignty is either by defeat in war or by voluntary abandonment of it formally evidenced.
Good evening. There's agreement tonight on the First Amendment to our new Constitution. It comes at the end of a two-day conference on native rights. The amendment doesn't promise immediate action, it promises more talk. Native leaders now have a guarantee they'll be sitting down with government leaders again to talk about their rights. Whit Fraser reports.
The problems the native groups in the provinces and federal government had today were perhaps more because of their different traditions than different political beliefs.
Much has changed in Canada since 1983. We're now facing a crisis with climate change and damage to our ecosystems due to the exploitation of natural resources, which is polluting our water and deteriorating a way of life and the cultural traditions of Canada's First Nations peoples. The Tsilhqot'in Nation is a great defender of our water, nature, and land in British Columbia, where I live. They understand that if the lakes and rivers are not clean, that their way of life will come to an end. They're thinking about the bigger picture and understand that through environmental stewardship, we can have sustainability for more years to come, so future generations can enjoy what we've abused and taken for granted.
This journey is so important because it's been 20 years in this country of Canada. The Constitution talks about Aboriginal rights and title, and yet First Nations, Aboriginals across Canada are still struggling. We're still fighting for our Aboriginal rights and title.
When we look at this case and where it's headed, you know, the issue of Aboriginal title is starting to break down some of those legal fictions that have withstood the test of time far too long, we believe, and we're very honored because we do know that this case is a potential precedent for the entire nation.
I pray in a good way that it comes out in a good way because, you know, I think all our ancestors are with us on this, you know, and they're with us supporting us, and everybody along the way, everybody is supporting us, all the people that have been hosting us, and, you know, it's just an honor to be here. And
yes, we need the land. We need the land for our future and give all our people hope. I mean, we're going to Ottawa, Supreme Court of Canada to get title. And I know with the previous one before this, they are introducing the postage stamping, but all I gotta say is no thanks. We already got that. We got reserves here and there all over our area, and it doesn't work for us.
too much destruction is happening to our land, and we don't like what we see. So that's what we are doing here, you know, that fighting for our very existence and rights, and you know, it's not just for us, it's for all the native people right from Canada, right across the world, I think, you know.
This is the most important case that is before the country. And so as such, this is one of the most important moments in the assertion of who we are, of standing firm in our title and rights.
And you do us all very proud by making the stands that you have and that you continue to do to bring us here to Ottawa as we complete this portion of the journey going to the Supreme Court of Canada.
We as people testified in this trial about our land, about our ways, and how we honor our lands, our resources, our people.
There's only one decision we will accept, and it's long overdue in this country. And that's full acknowledgement of our Aboriginal right and title. Long overdue.
I wanted to acknowledge all of the elders that traveled from Chilcotin country in British Columbia to be here today. A journey that really symbolizes the journey that Aboriginal people have taken in the courts over the last 40 years, fighting for our rights, and coming here today, Chief Roger, seeking the first declaration of Aboriginal title in this country.
The only acceptable decision for the Chilcotin people, for the elders, for all Indigenous peoples of Turtle Island, and certainly for the citizens of this country to complete the business of Confederation, for the Supreme Court to take this opportunity to bring forward an honorable decision that fully acknowledges and embraces the title, the Indigenous land rights of the Chilcotin people, in order for that to lay the foundation for true and genuine reconciliation to begin to take place.
This litigation was provoked by forestry activity, provincial forestry activity, so it was a defensive action. That finding was made by the trial judge and the Court of Appeal. So if you like, the claim area was defined from the outset in response to threatened, devastating forestry of what the Chilcotin perceived to be their Aboriginal title lands.
It's all backwards. They need to start listening to our laws and the Chinsarikan, like that's our law.
How did the province gain control of the homelands of Indigenous peoples in British Columbia in the absence of treaty? To shift the colonial paradigm, to complete the unfinished business of Confederation, this court, we ask, acknowledge the centrality of land to the Chilcotin and declare Aboriginal title.
It's an incredibly important case, not only in Canada, but from around the world. And I would say actually more broadly for the cause of human rights, because the situation of Indigenous peoples, the denial of their land rights, the suffering and the harm that causes is one of the most crucial human rights issues of our time. And what the Chilcotin are doing here today are advancing a standard that everybody should stand behind.
HGG submits that the only practical compromise is to construct a new paradigm. based on the promotion and protection of human rights by integrating the framework of international law into the domestic Aboriginal rights law to provide a way forward to achieving reconciliation through more effective processes.
It's very exciting and heartening to see the Silcotin people finally get their day in court, for the elders to be there and for their voices to be heard. We're very hopeful the Supreme Court of Canada will take into account all of the evidence that those elders gave, all of those years of trial, and affirm what the trial judge did several years ago and finally declare Aboriginal title to this core of Hanigwitine and Silcotin land, setting a precedent for Canada and hopefully setting a new way forward for First Nations and Crown relations for all Canadians into the future.
Regardless of what they say here, we're already winners, because the more issues that come down the pipe, if we don't get the answer we want here, there's going to be a lot more disruption.
No matter what, we will own this land. That we don't own it for ourselves, but it's given to us by our Creator, only for us to borrow, to pass on to the next generation.
It is an historic first and a landmark decision that could have huge implications right across Canada. It came from the Supreme Court of Canada, a unanimous decision today handing victory to a British Columbia Aboriginal group, ending decades of battle over its right to a piece of land. The case revolved around this 4,000 square kilometre tract west of Williams Lake, BC. The court ruled the group does have title or rights to about 1,700 square kilometres of it, to use, enjoy, and more. But what about those implications? They'll touch government, industry, and any future economic or resource development on First Nations lands, including the newly approved Northern Gateway Pipeline. We have full coverage tonight, beginning with more on the decision itself from Duncan McHugh.
What Roger Williams and the Chilcotin chiefs told the courts their ancestors had been saying since settlers first arrived. Their lands were still theirs. Today, Canada's highest court responded.
I was ecstatic to find out that we had title, and it's about time.
For more than 20 years, the Chilcotin argued forestry officials had no business permitting clear-cuts in Chilcotin traditional territory without consulting them, because their rights were tied to a vast swath of BC's interior where they hunted, fished, and lived. No, responded the province, those rights only exist in tiny areas, such as their old village sites. After hearing the claim, the Supreme Court of Canada was unanimous. The Chilcotin hold Aboriginal title to over 1,700 square kilometres, stating the title holders have the rights to the benefits associated with the land, to use it, enjoy it, and profit from its economic development. And where title is found, governments and others seeking to use the land must obtain the consent of the Aboriginal title holders. It's the first time the High Court has recognized Aboriginal title to a piece of land. Yet the justices made clear it still falls to the province to regulate land use decisions in BC, and the province can justify development if it's, quote, in the public interest. First Nations declared victory.
This has to be the wake-up call for governments, both the provincial and the federal governments.
With large parts of BC not covered by treaty, the ruling will most certainly impact resource extraction industries, such as oil and gas, mining, or logging.
And we're moving away from the world of mere consultation into a world of consent. And that is absolutely enormous when one considers Enbridge's Northern Gateway Pipeline proposal, the Kinder Morgan Pipeline proposal.
The BC government cautiously welcomed certainty around the rules.
We've seen the benefits that come to First Nations communities, and indeed to all of us, when First Nations have the opportunities to fully participate in the economy.
Before today, Aboriginal title was kind of a theory. It existed somewhere out here, but no one was sure where. Now we know First Nations essentially control pretty hefty chunks of their traditional territory, and Peter, there's no question that this is going to shake up the BC treaty process.
You're right, Duncan, but it doesn't end with BC. There's a lot at stake here for Aboriginal groups right across Canada, right?
Yeah, certainly in parts of Ontario, Quebec, the Maritimes, anywhere where land cession treaties don't exist. And the decision makes pretty clear, there's no question that Aboriginal groups are now going to have a stronger hand at the negotiating table.
All right, Duncan, thanks very much. Duncan McHugh in Vancouver tonight.
This area, which we consider that's our most sacred site. As Chilcotin people, the higher the elevation, the more sacred that site is. That's what our people believe. Because we as First Nation people, we don't believe in big, huge structures. We believe in the smallest impact on the land. So our churches and stuff are all out in the open in nature. Such as the river, this is the heart of the Chilcotin, is its good, clean river here. And that's what we've always fought and protected. And as a result, we have the largest, most consistent sockeye run on the Fraser River system. That's what this is all about. It's about the heart of the Chilcotin, the heart of our spirituality. We hope and wish that people would just leave us and our beliefs and our spirituality to us and not continue to attack. And that's what's happening here with this project, whatever being proposed. So people wonder why we fight so hard. You attack somebody's belief system, you attack their religion, their spirituality, they're gonna fight back, and that's where we're at. So, you know, we call on everyone, get a hold of the provincial government and let them know how you feel. We call on anyone to come out to support us out Tilton B, Fish Lake, you know, where we're peaceful people, but you know, we will fight for what we believe in, and that's where we're at again, unfortunately.
Now, after successfully opposing 2 mining proposals at Fish Lake, a place of profound cultural and spiritual importance to the Tsilhqot'in people, the Tsilhqot'in now face an imminent threat of an extensive drilling program in the same area for the purpose of advancing a mine proposal that the federal government rejected and cannot be built as matters stand.